All right, let's get started, ladies and gentlemen. Welcome back to the Lear Competition Festival. Yesterday, I think we had a very fruitful day with three very interesting sessions. The first one about the role of income or wealth distribution, or fairness, if you like, in competition law. The second session was managed by our partner, Freshfields, and was about the assessment of merger in digital market. And then we had this session in which the finalists of the Young Talent Competition Award had a chance to present their research projects. And then we announced the winner of the award. So let me remind everybody that you can find three shortlisted research projects on the festival website, which is learcompetitionfestival.com. Now, today we have an intense program. We will start with the National Competition Authority Chairs Roundtable. Then we'll have a know-how session managed by Osborne and Clarke on the design and implementation of compliance programs. Then the hot cases session managed by DG Comp on the retrospective analysis of competition policy. And finally, the day will end with the LCF Talk, which is managed by our partner, our media partner, Parr. So very intense program. And so without further ado, let's get started with the first session. Let me personally thank Andrea Coscelli from the UK Competition Markets Authority, Cani Fernandez from the Spanish Competition Authority, and Johannes Lianas from the Hellenic Competition Commission for kindly accepting our invitation. To chair the session, we couldn't have chosen a better person, I guess, Makis Kominos, who is himself a former member of a national competition authority. And currently a partner at White & Case. So Makis, you can take the lead of the festival. And
very good. Thank you.
Enjoy.
Thank you, Paolo. We have an hour of discussion in this National Competition Authorities Roundtable, which is actually a misnomer because the CMA is no longer, sadly, a national competition authority. It's a competition authority. But still, I mean, the term has survived, let's say. Let us discuss, we have identified a couple of topics to discuss. One is obviously the latest developments in the digital sector, how competition enforcement is dealing with the challenges in this sector, but also the interaction between competition enforcement and regulation. I mean, all of the jurisdictions represented here will definitely need to deal with such challenges in the very near future. So speaking about digital, I mean, the question is here, first of all these latest developments and proposals that we have, how related they are to competition law enforcement, first of all. Is it close? Are they closer to regulation or are they closer to competition law application or enforcement? Is there a rule of precedence, for example? Should there be a rule of precedence between the two? What is the role in the particular EU, let's say, area? Andrea is not, let's say, directly affected by that, but in the EU say in the EU area, I mean, what about the role of national competition authorities or national authorities, generally speaking? Because currently we see that the DMA is exclusively going to be, at least that's the proposal, the Commission will have exclusive competence when it comes to the major kind of actions that the DMA implies. So these are essentially all the questions that we have in mind. I would like to start first of all with Andrea, whose position is slightly different than Kani's and Yannis's, in the sense that there's no DMA there, plus the proposals are about a system which is institutionally different from the EU system, although in substance, at least I believe, is very much the same. I mean, there's not so many differences. So, Andrea, the floor is yours.
Great. Thanks, Makis, and thanks, Paolo, for inviting me. So let me say a few words on where we are in the UK. So as people know, the UK in many ways was the first mover on some of the intellectual work in this space with the Furman review a couple of years ago, which was, I think, a very good report, trying to bring in a lot of learnings from ex-ante regulation in telecoms, of financial services and other sectors to digital. And very much with the view that it might be useful to have ex-ante rules as a complement to ongoing ex-post competition enforcement. I personally always felt that was the way forward. I spent a few years working as a regulator, so I'm personally very relaxed about the tools that are used, in the sense that what really matters is the outcomes and the effectiveness of the particular tools. So for me, that's absolutely the way forward. So I've been very happy when Margaret Vestager and others have pushed forward similar proposals in Europe, and I'm very happy to see the DMA, and obviously similar things are happening in Australia, happening in Germany and in other places. I mean, in terms of the UK, then I think it's fair to say that we are now slightly behind, partially because of just a kind of heavy lifting on Brexit in the UK Parliament, and obviously COVID impacted us and others. So where we are at the moment is the government asked us to give expert advice to it about this ex-ante framework. And we did, I think, a good piece of work between the summer and the end of last year. And we delivered this digital task force report, where we work also very closely with the key regulators in the UK to produce it. And that's essentially a blueprint for what we think should happen. Now, we've always been very clear that at the end of the day, it's a political choice exactly how much power you give to this new regulator, who is going to be the new regulator, how it interacts with a number of things. So we try to preserve the optionality in our advice in a number of areas. The core part of the advices, I think people are by now familiar with, is essentially a process of SMS designation. So identifying a handful of large platforms that have very strategic market status. And if you are designated as a company, then a number of things come in, the main one being a code of conduct, which we think would need to do a lot of the heavy lifting in terms of the interactions, or business-to-business interactions in a number of these markets, and also obviously some of the business-to-consumer interactions. We work quite hard on processes, because we think at the end of the day, substance matters quite a lot, but processes also matter a lot. One of the problems with ex-post competition in digital, as I think we all acknowledge, is that they take too long, and that's a real problem for markets and for general deterrence. So we're quite keen that the regulator can use statutory timetables, very clear timing. And in many ways, the way I think about the regulator in this space is almost like an arbitrator or an adjudicator in a number of matters. So that, in a sense, you want a kind of two-stage process, where there is a process in front of the regulator, which is reasonably focused and streamlined, obviously with all the rights of defense, and then an appeal process, which also is proportionate to the issues at stake. The other two areas where we focus our advice, one is what we call this kind of SMS merger regime. So the idea of having a special measure regime that comes with a definition and designation of SMS company. So essentially, a different standard of review and a more cautious standard of review, and also some obligations in terms of transparency and information to the regulator about M&A activity, which again, we think is a very useful complement. And then finally, what we call the pro-competitive interventions, which would be one-off interventions to go to the source of some of the competitive problems, as opposed to just mitigating the effects with the code of conduct. The government has broadly welcomed the package. Government in the UK is currently working on a consultation document, which is part of the pre-legislative stage. We expect the government to go out and consult in the coming weeks on that, and then hopefully to introduce the legislation in the sort of spring to summer of next year in the next session of Parliament. In the meantime, the government has decided to create a shadow function in the CMA, so to give us this role of regulator, and have given us the funding from the 1st of April of this year for a smaller version of the unit. And so what we are doing now with the unit is essentially three things. One is working with the government on legislation. The second one is doing some sector inquiries, some substantive work, which we think is helpful just so that we are ready from day one to regulate when the powers come into place. And thirdly, we've been very clear in terms of our digital strategy that we are using our current powers to the fullest extent. So the last few months, we've launched three significant antitrust cases, one against Apple on Apple stores, one against Facebook, and one against Google on the privacy sandbox. And we have a number of detailed merger inquiries in the digital space as well. So we're certainly trying to keep ourselves busy and impactful during the gap, because there's definitely going to be a gap between now and when these new powers come into effect.
Right. And let's say you say we want to be ready in day one. Let's say now that you are in day one, how are you going to how are you going to exercise your competition powers, for example? Do you have in mind some rule of precedence here? Oh, this is for regulatory intervention, that's for the good old competition law intervention, etc. I mean, what do you have in mind?
Yeah, so in the UK, I think we're slightly more relaxed about it, because if you think about the two main sector regulators, Ofcom, which is doing telecoms and media, and the FCA, the financial services, they have both competition and regulatory power. So there is quite a lot of precedent about thinking about what is the best tool for particular issues, and also having guidance about it. The other point, which I think is very important to make, is that we currently think that designation will only affect a small number of digital companies. So there's going to be quite a lot of the digital work that will continue to be done exactly what we're doing now with ex-post competition powers. And we are very, also the government in the UK is not a government that is particularly keen on extensive regulation at the moment. So, in the end, it would be for them to decide the powers of the DMU. But my expectation is that the government will be quite careful that we keep using our competition powers in a sense as much as possible. And we only use the ex-ante regulatory powers really to deal with clearly well-defined gaps.
Right. Yes, I mean, we see that the UK system has some differences with the proposed DMA. For example, in the DMA, we don't have anything on a special merger regime that you mentioned. There is a provision in the DMA, but that's only for information gathering. It's not really a notification as we know it. And there are also some differences when it comes to substance. I mean, in the DMA, we have specific prohibitions. I think your proposal is for a more kind of flexible, let's say. But let's go to Kani. I mean, obviously, the question for an NCA chair, Kani, is how do you feel about the DMA? Do you feel that you're left out? I mean, why? Do you agree with the Commission's exclusive competence here? But I'm not going to be as direct as that. I would like first that you tell us about these challenges, and yes, I mean, why not? What role would you see for national authorities in this area? You're still muted, I think.
Bottom left.
Can you hear me now? Okay. Thank you. Sorry for this. Thank you very much. Good afternoon, everyone, and thank you, Paolo Buzzirosi, for the invitation. It is a pleasure being with you. Yeah, well, as you know, the DMA that is now being discussed by the EU institutions is not only debated there, but it is also very highly debated, and it's a very hot topic for all the national competition authorities and all the national regulatory authorities as well. It is true, and this audience is already aware that, well, in fact, the DMA is trying to cope with the frustration that some enforcement gaps, if any, have been detected in the digital markets. And as you know, basically, the DMA consists of a list of do's and don'ts for large digital platforms that qualify as gatekeepers. And this approach is seemingly different from that of the competition law provisions, Articles 101 and 102 of the treaty, in that the DMA is a set of general ex-ante rules, whereas Articles 101, 102 would only come ex post and case by case. And indeed, the DMA declares itself complementary to the competition rules and indicates that its aim is protecting a different legal interest from those rules. However, both set of rules, the DMA and the competition rules, might eventually collide, since the DMA would be applied in principle faster, and its investigative requirements would be significantly lower than those of competition law. It is not hard to imagine that the DMA could prevail over the application of the competition rules in those cases. The DMA will therefore apply not only to instances that escape the scope of the current competition rules, but also to cases that could be targeted by both set of rules. And this implies the necessity to set up strong coordination mechanisms between the application of the DMA and that of competition law provisions, not only within the European Commission. You know that now that there is this debate on whether it should be DG Connect, DG Comp, or a group of people in order to enforce it, but also between the European Commission and the national competition authorities of the member states. Just as the enforcement of Articles 101 and 102, that requires strong coordination between the European Commission and the national competition authorities to avoid parallel investigations and discrepancies on the substantive analysis, or in order not to create different market conditions. A smooth enforcement of the DMA would require to set up, in my view, similar coordination mechanisms between enforcers. As you know, the discussions on the DMA focus in two main aspects: the substantive features of the DMA, which are extremely relevant and take most of the attention in academics and conferences, but also the procedural ones, which are, as Makis was saying, a particular concern for European national competition authorities. I would like to explore with you today specifically the procedural features of the DMA's characteristics and share some options to strengthen its institutional dimension. First, I believe the DMA should establish an allocation mechanism between the European Union, the Commission, and the national competition authorities for gatekeepers of national dimension or special national significance. Of course, you are thinking that probably a gatekeeper of national dimension is a difficult thing to establish, but imagine situations in which a gatekeeper that has a European wide presence is, for example, dealing with a particular app that has been created in a member state. It is obstructing this app of being, for example, used in the platform. That would be probably, in that scenario, the National Competition Authority may be better placed to deal with the case. Because national competition authorities can be better placed to enforce DMA where gatekeepers have this particular connection with a market, or even special significance in a given member state, which may happen. The allocation mechanism would follow, in my view, or should follow, similar principles to the allocation of 101 and 102, or even merger control cases within the European competition network. Therefore, in such scenarios, the NCAs should be entitled, in my view, to enforce directly the DMA provisions. Once you have defined the criteria, then there are no parallel enforcement actions, but allocation. For example, in Spain, we have some relevant food delivery platforms with significant market share that are, however, only present in Spain. In these cases, it would probably make more sense for the CNMC to apply the DMA rather than Brussels. Second, I also believe that NCAs should be able to formally request the opening of an investigation under the DMA. We have to avoid as much as possible parallel enforcement, and competition law with different applications should be avoided, because this would undermine the legal certainty within the European Union. And to this end, it would be sensible to set up a mechanism enabling the NCAs to issue a formal request to the European Commission to open an investigation under the DMA. Such mechanism could serve to efficiently allocate cases between the two instruments, the DMA and competition law, while at the same time preserving the efficacy of competition law enforcement by stopping the clock of competition cases, for example. Such mechanisms should include certain time limits in which the Commission should react to the national competition authorities' request to avoid uncertainty. Likewise, it would be advisable to be able to infer a green light course of action for the NCA in the absence of a reply within this given time limit, in order to allow the NCAs to be entitled to open investigations under the national competition or ex ante regulation, if they have it, in a timely and efficient manner. Likewise, I think it would be also worth exploring whether the NCAs should be entitled to request the European Commission to open a market investigation following Articles 14 to 17 of the DMA, designate a gatekeeper or review the status of a designated gatekeeper, specify, suspend, exempt, or update the obligations, and open non-compliance proceedings. I think those should be actions that the national competition authorities should be entitled to ask the Commission to do. Third, it is also interesting to clarify the role of the NCAs as regards the enforcement of the DMA in our respective territories. We can help enforce the DMA, namely by cooperating with the Commission in inspection downgrades in the territory of the concerned national competition authority, monitoring compliance with obligations imposed on gatekeepers, and sanctioning of non-compliance with the obligations under the DMA when they concern a single member state or have a special significance in a member state. We are closer to the facts, and I think we could be a better place to monitor. Fourth, in order to enhance cooperation and coordination, a very strong information system between the European Commission and the NCA should be envisaged. Coordination and consistency between 101 and 102 and the DMA require that NCAs are readily informed as regards the steps taken by the Commission under the DMA. Such information system could mirror the system already in place for allocation and mutual information in Articles 101 and 102 cases. The ECN notice following formal opening of procedure by member states and the early warnings from the DGCOM. These information mechanisms should apply to market investigations, designation of gatekeepers and review of their status, specifications, suspension, in fact, all the elements that I already mentioned for NCAs to ask the Commission to act. Fifth, it should be advisable as well to ensure that the NCA's opinion is duly considered by the Commission before adopting a decision under the DMA. This could be accomplished, for example, if NCAs are the members of the advisory committee. Now it is not clear whether it will be the member states or the NCAs. And the opinion of this advisory committee should be given actual significance in the decision-making process, for instance, by impeding the Commission to adopt a decision if a majority of NCAs are against, or introducing a duty of the Commission to motivate non-compliance with recommendations given by the national competition authorities. Last but not least, the system would be enhanced by enabling NCAs to reuse the information gathered under the DMA for the enforcement of Articles 101 and 102. With the necessary provisions on the respect of the rights of the defense of the companies, but of course the sort of information gathered by the Commission to enforce the DMA could be highly relevant in a competition case. And this process of gathering information under the DMA could undermine enforcement powers under competition law. This is namely the case of inspections, where a subsequent inspection would likely lead to poorer or no results at all. So this reuse of information by the public sector will reduce red tape for companies. The DMA should explicitly provide, in my view, such possibility, while, as I was saying, at the same time preserving rights of the defense by the parties. To sum up, as NCAs, we should pursue three main objectives. Make sure that information flows, try to ensure that the problems are tackled by the best placed authority, and most of all, guarantee that restrictions of competition are fought timely. I believe that the measures just explored would head us in the good direction. Thank you.
I see, Kani, that you start from, let's say, communautaire position, which is you accept in principle the central position of the European Commission in applying the rules all over Europe, but at the same time you nuance a bit this position afterwards and you say yes, but the NCAs or the national authority, generally speaking, should have a role. I have to say, I mean, I can certainly understand the position that the Commission has, or at least it's a starting negotiating position, let's say, which is the Commission should have a central role. Maybe there is a role for NCAs for sure. What I find startling, however, is while the current proposal essentially does not give powers to the NCAs, I mean, or to national authorities, this is the current situation, because of fragmentation risks, I find quite startling that the DMA would be open to private enforcement. So the judges from Palermo to Helsinki and from Iași in Romania to Porto would be able to issue injunctions in private enforcement cases. So you would have mini regulations, you know, all over Europe. So we kind of leave that open, while for the NCAs, we are extremely closed, and we say no, there should be exclusive competence of the European Commission. I mean, exclusive competence has a role, but as you say, there may be some role also for the NCAs. I don't know if you ever thought about the private enforcement parallel, and if you have given an explanation why the NCAs are treated differently.
You are absolutely right, and that is one of the points that we are discussing with the Commission, particularly because the scheme of the DMA has no precedent. I mean, if we go to the application of 101, 102, the decentralized application is everywhere. It's not only national competition authorities, but also judges, and things are working remarkably well, I think.
Sorry to interrupt. Incidentally, I believe that it's not good, I mean, to have too much decentralization. So I would restrict a bit private enforcement, if you ask me, to follow on cases instead of standalone cases. But I think it's a fair argument that certainly national competition authorities can also use.
Yeah, and you can take that example, or you can take the example of merger control, where there is a centralized approach, clearly, but there are also cooperation mechanisms, collaboration mechanisms, in order to have a one-stop shop, but with everybody involved having the best placed element there. So one or the other, but I don't see the benefits of keeping exclusive jurisdiction only for the Commission.
Yes, there has been a proposal by some to give the national competition authorities powers to gather complaints and then forward the complaints to the Commission. Anyway, let's go to Yanis. We were discussing now, Yanni, about the role of NCAs. We mentioned the advisory committee, the DMA advisory committee, but as Kani said, it's not clear which would be the members of the the DMA advisory committee, and will it be national competition authorities, or will it be some kind of other national authority? So, you know, we seem to take for granted that it would be NCAs and CAs that would have a role, but maybe it's not NCAs at all. It's some other NRA, you know, which will be, I would say, responsible. But what are your views about the competence issue, generally speaking? And then maybe we go about whether it should be NCAs and NRAs or whatever.
Thank you, Makis. So let me just say that the reason we are having the DMA is basically the idea that we are facing two sorts of gaps in the current structure. The first one will be, I would say, the so-called regulatory gap, in the sense that our substantive law currently and the requirement of dominance in a specific relevant market, as well as the somehow the difficulty to deal quite quickly with these complex cases might create a problem for the enforcement of competition law to deal with these problems, in particular tipping markets issue, network effects, learning effects. And we have tried to improve the current framework, you know, by using more interim measures, for instance. But you know, you can go as far as that. So there is the idea that there should be some kind of enforcement, regulatory gap here that we need to tackle. And I think that has led to a number of proposals also at the national level, Germany being one, but also, you know, the use by other authorities of the older doctrines of abuse of economic dependence, or, you know, the recent proposals in Greece for abuse of ecosystem power, or in Italy as well. I think there's been discussion about that, so as to somehow improve the ex-post enforcement of competition law. And then, you know, there is somehow also, unfortunately, the idea there has been an enforcement gap, in the sense that the competition authorities haven't applied as actively as they should probably, and as early as they should, the competition law provisions to the digital economy, which I think is a little bit unfair to the competition authorities' work, because we have seen a number of big cases coming up from a number of course, from the European Commission, but also from a number of NCAs. And, you know, I mean, we have a number of NCAs that have imposed considerable fines with regards to big tech platforms. Now, having said that, you know, and this is a little bit linked to the question, should we deal with that at the EU level or national level? I would say that, you know, the authorities that have been able to deal with the big tech platforms are the competition authorities of the big member states. I mean, it's quite difficult for smaller member states to enforce competition law provisions against some big tech platforms. Some of them have actually a market value that is many times more than the GDP of the specific member state. So that means that we need to have an EU enforcement level, a very strong EU enforcement level. And there, you know, we have already competition law provisions ex post and some ex ante, like merger control. And I think the idea is to add EU intervention through an ex ante mechanism. That's what the DMA is trying to do. Now, but having said that, the DMA, and it's very clear both in the preamble, Recital 10, as well as Article 1, Paragraph 6, is complementary to the current EU and national legislation. So it's not actually, it doesn't substitute the competition law provisions. And I think Recital 9 and also 10 provide to national competition authorities the possibility to enforce also national competition law provisions that might help ex post, that might help to deter possibly through the enforcement anti-competitive practices that could fall under the scope of these provisions. And even if in the most expansive scenario for the scope of the DMA, NCAs will still be able to intervene by enforcing ex post competition law if firms engage in conduct not explicitly prohibited by the DMA, as well as against digital platforms that are not gatekeepers according to the DMA. And we can think was a criteria of Article 3, Paragraph 6 are the ones we have, and they're pretty high. We can think of a number of important digital platforms that may not necessarily fall under the gatekeeper qualification, and therefore, national competition authorities could apply competition law in this context. Now, of course, there's an issue there because there might be some misunderstanding because we use the term ex-ante regulation that this is something like sort of a sector-specific regulation. It's not. Here we're talking about a sort of a specialized competition law rather than a regulation. I mean, the legal interests, of course, are different from the ones that we are trying to protect through the enforcement of competition law, because here we have, although I mean this is mentioned in the text of recital 10 of the DMA, although I have to say it's not very different. So from the perspective that we are aiming to protect effective competition as well as fairness, and for some fairness constitute a legal interest or objective, let's say, of competition enforcement as well. But so we cannot necessarily say that this is like a sector-specific regulation. It's not. It's actually a sort of specialized competition law.
I'm surprised you admit that, Yannis, because
well, I have to say, but that doesn't mean that actually it falls under the nebis in idem, or it could fall under the nebis in idem type of requirements, because precisely not exactly the same legal interest as the one protected by Articles 101 and 102. So there's some difference. And from that perspective, I think it obviously would depend on the way the court will interpret nebis in idem in the context of some pending cases, in particular C1720. But I think, from my perspective, it is different, although it's not sector-specific regulation. So in terms of the problems that we might have in this context, and is the fact that we are we have national competition law, we have Articles 102, we have the DMA, we have actually also regulation, the Platform to Business Regulation 2019-1150, which also have somehow different objectives possibly than the DMA, although this is not mentioned in Recital 11 for Regulation 2019-1150. I mean, it's only mentioned for competition law provisions. And we need basically to somehow create a system of interaction between these various texts and provisions, as well as between the EU and the national levels. It's pretty complicated, and I think one of the problems that we have so far is that maybe we put the cart before the horse, because we have been discussing about substantive rules without having in mind a specific institutional design and how actually we can enforce all that. So I think the question of institutional improvements and institutional design will be extremely important in the way we will continue the discussion for the DMA. Right. So I fully agree there with Gani's proposals, and I will not repeat them. We need a mechanism ensuring an adequate exchange of information between the European Commission's team enforcing the DMA, all national competition authorities eventually, and DG Comp, of course, with regards to the enforcement of DMA, in order to avoid issues of negative or positive conflict with competition law. We need to ensure that in the Digital Markets Advisory Committee, we have national competition authorities as the Euro members. I don't think it's actually, I think it's a little bit strange to suggest that national regulatory authorities will be part of this, because the main problem that this advisory committee will have to solve is the interaction between competition enforcement and DMA enforcement. I mean, how can national regulatory authorities help with regards to that? I think the only acceptable option here is to have the Euro members of this Digital Markets Advisory Committee, national competition authorities. 3, we heard that some might go even further and call for providing NCA's jurisdiction to implement the DMA. I mean, I'm favorable to that, but I think the most important thing right now is to ensure that the EU, at the EU level of enforcement, the one that will enforce will be DG Comp, because I think this will ensure the appropriate interaction between the DMA and competition, which I think is one of the most important concerns I might have, because we don't want to create a system that will overlap or we sometimes create tensions with another system that works pretty well, and we have already established.
Okay, let's stop here. I mean, and let's have I have a couple of questions, let's say, but I would
like to add one more thing, Mikey, because this is something you touch upon, which is a private enforcement aspect. I think this is definitely something that hasn't been discussed as much as it should. And the same way that we try to harmonize procedural rules governing the, for instance, actions for damages for any infringement of competition law with Directive 2014/104, I think we'll have probably to think about a similar approach with regards to the DMA as well, because I think another of the challenges that we need to face, apart from the coordination of the public enforcers and the different, basically the DMA and the competition law provisions, is also the interaction between public and private enforcement in this context. And we haven't really done anything with regards to that yet. So I would suggest that what is urgently needed is probably a report, the same way we put in place a report by Heike Schweitzer and Jacques Lemaire and Alexandre Monchois for the substantive issues that are raised by the ecosystems and and digital platforms. The same way, actually, we need to now commission a report for the institutional issues and design issues that we need to tackle before we move forward with the final decisions with regards to that.
Right. Andrea, I mean, we hear a lot about coordination. I have 2 questions for you, and I would like to have your short reactions. I will have a couple of questions also for Kani and Yanis, so please, let's make it short. But my question to Andrea is, will there be an ICN for digital for the digital sector? I mean, for regulatory interventions of this kind? And then here I might be putting you in a difficult spot. From an external observer point of view, is there something in the DMA that you would like to have and you don't have for the UK? And is there something in the UK proposals that you think the EU should consider introducing?
Okay, I will be very brief. So on coordination, I don't know. It is possible that in future there might be an ICN with regulators who work on ex-ante rules on digital. If most of the regulators sit within competition authorities, I certainly think the ICN could do the job. So I think we just have to wait and see what happens in terms of institutional design in the different countries. On the DMA versus our proposals, I mean, I think there's going to be quite a lot of interplay, because when our proposals go through Parliament in the UK, I mean, the DMA is clearly a very important focal point, because clearly, in a sense, if you think about businesses adopting pan-European models, there's clearly an incentive for everyone in having similar models. Now, I mean, in many ways, it goes to the heart of the Brexit question, to what extent the British Parliament would be comfortable deviating, and I'm sure people parliamentarians will think about the pros and cons, which obviously vary by area, by matter. So, I mean, as I said, I think the spirit of what the Commission is trying to do with DMA is very similar with the spirit of what we're trying to do in the UK. the institutional arrangements at the moment look quite different. And also the case by case assessment versus the list and all of it. But it might be that we all end up borrowing something from the other proposals. I mean, I think we just need to see. There might be more convergence eventually than it's the case right now.
How do you explain? I mean, the UK historically has been a diacon of non-state intervention against the dirigism. We believe in free markets, competition law. And in fact, some people were very sorry to see the UK leave the EU because of this particular influence of the UK. And yet we see recently, over the recent years, a certain, a more kind of openness towards intervention, dirigism, this kind of the French idea of the state has to set the rules, etc. It's quite, I would say, surprising for us external observers to see the UK now being the champion in these areas.
Well, I mean, I think, my personal view is that we are much more effective as competition authorities. We are kind of expert advisors about markets as opposed to be just focused on kind of deregulation. I think it's if we interpret correctly our mandate, which is to promote growth and productivity in our economies, I think proper pro-competitive regulation is pro-markets and pro-business. And a lot of the problems at the moment with the lack of enforcement is that it's just great for incumbent players and for their shareholders, and it's bad for consumers and lots of businesses. I do receive almost every day letters and emails from businesses complaining about the practices of some of the big platforms. So I think it's an incorrect reading in the sense that what we are after, and I think what we have convinced the UK government to be after, is really competitive markets. And it's quite interesting if you look at people like Luigi Zingales in Chicago. These are pretty free markets people, and they're very unhappy with the current state of affairs, and they think more intervention is needed to deal with some of these companies. So I think it's kind of, I would call it an early 2000s way of looking at it, to put it that way. I think things have moved on.
I think we're living in a different phase of competition law. Maybe in 15 or 20 years time, we'll go back to exactly. Chicago, again, who knows?
No, exactly.
Kani, I mean, you made your point about the role of national authorities, national competition authorities, but I think you agree also that, these are global issues. We're talking about, especially the GAFAs, these are global companies. The challenges are global. And obviously, you agree that the Commission should have a central role in implementing the DMA, although you are pleading for some specific powers to be, let's say, some rights of referral, possibility of referral, let's say, for some specific powers to be recognized from NCAs. Can I ask you, which ones do you think, I mean, pragmatically speaking, which ones do you think that you would really need to have once the DMA becomes operable? Which ones do you think are sine qua non, I mean, that really would be necessary for your daily enforcement activities?
Well, I think mainly, I mean, the my view more important are two. The first one, the possibility of enforcing our own equivalent law if existing, or if the Commission doesn't reply in a given period of time. I mean, we need to react quickly. There are many situations in which either you react quickly. For example, the example I was given is a real example. I mean, imagine that you are an innovator, you are creating an app, and any of whether it is Google or Android, or Google Android or Apple, imposing on you barriers to download the app in your mobile. Either intervene immediately, or there is a risk of copying that up that will happen. I mean, so you really need to react quickly. So either the Commission decides to react, or you have to be free to act quickly. So that will be one. I mean, a system in which the Commission has a first opt-in situation, to say it in a way, but otherwise we are free to go.
But that you would have your national competition law to do in any event. You don't need the DMA for that.
Yeah, and then imagine that the Commission decides to open a DMA later on. What I am going to do with my competition case? I know, wasting resources. No. I think it is either, I mean, we have to coordinate very, very well there, because otherwise I mean, this is going to be a parallel enforcement with different tools, I'm sure. And then the second one is the possibility of reusing the information gathered during a DMA investigation for the application of Articles 102 and in particular 101 eventually. But that I think is very important, because if the Commission decides, due to limited resources or priorities or whatever, that they are not going to pursue that, then our enforcement powers are completely washed out.
So essentially what you're saying, you are pleading really as a minimum to have coordination mechanisms. You are pleading essentially to have the equivalent of Article 11 in Regulation 1/2003, the equivalent of Article 15 and 16 of Regulation, which is true. I mean, these provisions are not, you don't see these provisions in the DMA.
Yeah.
No, that's a good point. And going back to Yanni, I mean, what do you think, Yanni, in terms of making from a substance point of view, in terms of the specific obligations? And we have discussed it another time. Do you think it might be a good idea to introduce also some flexibility in these prohibitions by having, for example, a general clause? Or you are more favorable for this kind of per se approach because it's for legal certainty, no worries about different errors of enforcement, etc. Legal certainty is better. Would you be in favor of introducing some flexibility in the system? That's my question.
Okay. Let me say the following. I mean, you know, this is what the Commission is trying to do here is to harmonize the ex-ante intervention tool for specific types of practices and for specific types of actors, the gatekeepers, which means that for the rest, member states and the rest meaning the ex post and the ex-ante not being offering platform core services and being gatekeepers, member states are free to regulate and to develop their own provisions. So some of them have already done so. So that's basically the scope of the harmonization. Now, the tool that the Commission is using is a regulation. It's not a directive, it's a regulation that has direct effect. It's enforceable in also private courts across the EU member states. And obviously, that needs to have very specific type of domains of application. I mean, so the judge or the enforcers will have to know very clearly, and the companies, of course, will have to know very clearly what is prohibited and what is not. Now, and the Commission is also making a distinction in recital 9, basically by saying, look, this is not like competition law to the extent that, and it doesn't affect, let's say, is without prejudice to either Article 101, 102, or national provisions regarding unilateral behavior that are based on an individualized assessment of market position behavior, including its likely effects, and also taking into account efficiency and objective justification argument. So, I mean, it's a clear distinction that concerns the scope of application of the DMA. So I think it doesn't make any sense, the discussion to add an extra flexibility and transform the DMA from an ex-ante regulatory tool to some form of ex post competition law to, or ex nunc competition law to. I mean, it's not the purpose. I mean, if we want to have that, there is the possibility for member states to adopt such rules. So I think the only flexibility I will see is in the way we determine what is a gatekeeper. I mean, when you look to Article 3, Paragraph 6, for instance, you may take there into account the business models, because it's a different way that, different problems that might occur through a ad-based business model than through any other type of business model. But that would be about the definition of a company as a gatekeeper. But once this, if it is defined as a gatekeeper, I think that's the end of the story. And in my view, adding, creating some kind of DMA paragraph 3, I mean, with object justification, etc., it's basically defeating the whole purpose of the DMA tool. And let's not forget, the private enforcement of that specific DMA. And the institutional issue that I raised before, which is still unresolved. I mean, and the question there is the following. I mean, we need to be pragmatic. We need to act quickly. We cannot take we don't have the luxury of creating a de novo enforcement system that will deal with DMA, and that will be added to complementary to the one we have for competition law. I think the most obvious option is to use the well-functioning EU-wide enforcement system that we have that results from Regulation 1/2003, the ECN Plus Directive, the Cooperation Guidelines, Directive 2014/104, with specific and now well-known rules regarding allocation of jurisdiction, cooperation, rules regarding investigative powers, procedural requirements respecting the Charter and the ECHR, to which the DMA enforcement system should be anchored. That will avoid the problem of the negative or positive conflicts between the DMA and competition law in view of recitals 9 and 10 of the DMA. And my question is, why add more institutional complexity to a system that is already complex enough and has already different layers of interaction, for instance, between NCAs and sector-specific regulators, between the Commission and national sector-specific regulators, national courts and sector-specific regulators, rather than using the, for instance, ECN or the cooperation mechanism that we have between national courts, the Commission and NCAs. So I think what is important now is to think pragmatically and use the existing EU-wide enforcement system to serve the purposes, the specific narrow purposes that the DMA is serving, which is, as I've said before, harmonization of the ex-ante field for gatekeepers and for specific types of practices. Very narrow.
Very good. I mean, your point is clear. You don't want a DMA paragraph 3. May I remind everybody, however, that we are discussing without knowing what the ECJ, the European courts, when they come across the first cases, will decide. Remember that in the old days, it was the European courts which interpreted Article 101.1 in an expansive way, and they read limits in there. So who knows, the courts may play that role too. Final question. I understand that Paolo has been very kind and given us 5 more minutes. I heard with a lot of interest when Andrea was saying competition authorities are expert advisors on markets. I mean, so you accept the point about the technocracy that competition authorities represent in a way. But that technocracy has been extremely attacked, I mean, over the recent years. And so on the one hand, we hear the priesthood, the Economist article, the technocrats, etc. And on the other hand, the other line of criticism is that competition enforcement has become too politicized. What's your take on that?
Well, I think when I talk about expert advisor, I'm very clear about the distinctions between Parliament and us, in the sense that, ultimately it's for democratically elected governments to decide on trade-offs. So we tend to be very clear between, most of what we do, which is our core mandate, which is, to be an enforcer on merger control and competition and consumer enforcement. And then another part of our mandate, which is this kind of advocacy, market study, sector inquiry. So areas where we think we are a big resource for the government. Essentially, we are a microeconomics kind of public policy body. And we have the capacity to leverage our knowledge of markets from our core mandate and give good advice, we think, to government. Now, interestingly, sometimes government follows 100% our advice. Sometimes they follow some of it. And I think it's absolutely fine. I mean, obviously, as you would expect, we spend quite a lot of time talking privately to government as well. We try to identify areas of common interest. So we're not going to launch inquiries in areas where there is no interest for our input. But right now we're looking into things like children's social care. We looked into adult social care. We're looking at a number of areas linked to climate change, where, to be honest, most of the solutions are likely to be with legislative change rather than our direct action. There might be parts of it where we could do something with direct action. So I think that's an important area. I mean, on the independence versus politics, I mean, I think for me, merger control is one of the core areas of our mandate, obviously together with competition enforcement, where it's really important to preserve the independence. I think there are good reasons why independence was set up 20, 30 years ago in many countries, because obviously if you're a politician, you have a lot of short-term pressures, which we don't have. So I think we are more likely to end up in the right place in terms of medium-term solutions. So I'm very, very keen to preserve that. And luckily in the UK, we have strong independence. As you know, we also have this kind of double independence. So some of the merger, the phase 2 merger decisions are taken by a panel which is independent of me and the rest of the board. So it's a very strengthened form of independence. So, as I think you were saying, we need to evolve with the times. We need to remain relevant. We need to remain, I think, part of a kind of institutional setup that adds value for consumers and taxpayers. I mean, that's the only reason I think we remain relevant and we get funded and we can keep doing our jobs. I think it's really important to have the open-mindedness to accept some of the criticisms and to understand that there are times when we think we're perceived as being too insular, and some of our processes over the years have become extremely cumbersome and clunky, as we all know. And some of our processes just take too long in our core mandate. And I think it's really important that we constantly challenge ourselves to deliver within reasonable timeframes.
Very good. Yanni, can you give us within 1 minute what's next on your very interesting sustainability initiatives? The Hellenic Competition Commission has been at the forefront of the sustainability discussion, sustainability and competition law.
Permit me, Mikey, I would like to link this issue with a previous question, very interesting question you asked. I think, we have been facing some criticism from populist type of perspectives on the role of independent regulatory authorities in the context of democracy in recent times. And sometimes, some of the criticism are justified. But, and there, I'm not talking about the knee-jerk type of reactions of populist reactions, but actually really thoughtful populist attack to technocracy, from theories like Erdős Laclau's work on populism, etc. From the other side, I will say we have seen how important technocracy is in the context of the problem of the COVID-19 crisis, where basically we have been somehow depending on all our aspects of social life from the decision of certain technocracy experts, about public health experts, that enable us to, solve a number of problems, and the long-term problems that sustainability and climate change set for our democracies. And I think that there we have actually some interesting work by Piero Sanvallon, for instance, about the fact that democracy is not just about the short-term party democracy, but and decisions that are made, through the electoral cycle, but basically about long-term. I mean, how we deal within democracies, the long-term challenges that we're facing, particularly climate change and sustainability. And there, Sanvallon puts emphasis on the role of technocracy. So I think what we need to do is to rethink a little bit about our role as technocrats, in a sense. Independent authorities are basically that, in order to solve the long-term problems, so to develop basically a wider perspective, because this is exactly what is required from us, not really the very narrow bureaucratic. Technocracy is different from bureaucracy, yeah? Bureaucratic perspective of things. So taking into account not just consumer welfare, for instance, but actually also sustainability, linking the competition law enforcement with other aspects important for the quality of our social life, which are important, and at the same time, responding to the populist critique by developing links with civil society more intensively, by justifying better our actions, and by also participating more, in the policy debates, not politics, but policy debates we're having. So I think this will need to reimagine the role of not just competition authority, but more generally independent authorities, independent administrative agencies, in the new basically policy space that we're facing with all these important long-term challenges, the immediacy of democratic politics, because now we are
time is up.
Yeah, so we need basically to revise the way we think and reimagine our role in the constitutional structure of each system.
So, Kani, final word. Yanis is obviously speaking about a more holistic approach, which nobody would say anything against that. What's your view? I mean, are you, as head of the Spanish authority, do you feel a lot of pressure in this cleavage between technocracy, politicization, etc.? Or you have other more mundane challenges that you're grappling with?
I have more mundane problems. I still need to do the merger internally, the merger of the 7 authorities that gave rise to the CNMC in 2013. It is working very well, providing services, but inside I still have, just to give you an example, I have 5 different labor committees to negotiate and unions. So it's still, that merger is still to be done internally. That's what I am now mostly focused on.
Well, good luck, because these are the real challenges of an enforcer. Thank you all, and well, hope to see you soon.
Thanks, Marcus.
Bye-bye.
Thanks. Bye-bye.
Thank you very much, everybody. Thank you, Andrea, Makis, Kani, and Yanis. Of course, you're welcome to stay with us if you have time and you wish so. It's interesting to know that also competition authorities have problems with internal mergers. I mean, it's not just the...
Lots of synergies, though.
A lot of synergies. Now you can touch with your hands, the synergies you can get. Okay, very good. So we can move to the next session. Enrico Fabrizi and the other, I can see Nicola Lopez. All right. And Thomas, I don't see Enrico yet. Enrico, you can switch on your webcam. All right, let me introduce the session. Then Enrico will be ready.
Sorry, I don't see the. Okay, sorry.
It's on the bottom.
Yep.
Okay.
Yes. Hello. Hi.
Enrico. Okay, so we got to the second session managed by one of our partners. It's Osborne and Clarke. And they have 45 minutes to bring us in the world of antitrust compliance programs. Enrico, the floor is yours.
Thank you. I think Catherine, you can, if you want, you can start.
Catherine is sharing the session. That's correct. Sorry. Okay.
Can you hear me now?
Yep.
You can hear me. Right.
Can you see the screen? I've tried to. Okay, good.
I can see the slides. Thank you. Okay, I don't know. Sorry for the technical difficulties, but hello. I'm Catherine Kirridge. I'm a partner in the UK competition team of Osborne Clarke. I've also spent some time on secondment at Vodafone, and so I've seen from kind of both sides the importance of creating a living compliance program to drive a compliance culture. From my perspective, as I'm sure you know, the Italian Competition Authority is really interesting. It's issued guidelines that set out the key components for a compliance policy and offer specific reductions in the fines for companies that have or implement a policy in line with the guidelines. And so from kind of the outside in the UK, it's been really interesting to see how that approach has worked in Italy and the lessons that we can take away from it more broadly. So it's a real pleasure to be joined by my Osborne Clarke colleague Enrico Fabrizi and by Nicola Lopez from Procter & Gamble. They've worked together closely for many years and can bring today both those sides of the coin of developing a policy as an external counsel, but also implementing it and keeping it alive internally. First, I'll hand over to Enrico, and Enrico heads our competition team in Italy, and he's particularly well suited for this today as he's got extensive experience in designing and implementing antitrust compliance programs for companies in a lot of different sectors, as well as for consortia and associations. So Enrico, I'll hand over to you to get us started.
Thank you, Catherine. Thank you, Paolo, and thanks to Lear for the organization of this festival. I apologize for my voice, but yesterday it was even worse. So I will really do my best to make myself understandable. So as Catherine said, Italy is certainly a very interesting jurisdiction to look at when we talk about antitrust compliance programs, having regard in particular to the initiatives taken by the Italian antitrust authority in the last few years, and to what we can learn from the practical experience that follows such initiatives. As a background, in 2014, in its guidelines on the criteria to set fines for antitrust infringements, the authority expressly included, as Catherine said, the adoption and implementation of compliance programs among the factors that could justify a reduction of the fine that could reach 15% of the basic amount of a fine. So with this initial action, the authority already made a clear policy choice, encouraging the adoption of compliance program, basically considering compliance program as useful tools to promote the development of a common antitrust culture in Italy. We have then a second initiative that goes in the same direction, that was taken more recently at the end of 2018 with the adoption of specific guidelines on compliance programs. And again, the main objective of these guidelines from the point of view of the authority is to further promote the spreading of a competition culture within the business community. And in this perspective, it is interesting to note that the guidelines not only give indications to the business community on how to file a request for the assessment of a program in the context of an investigation, or on the criteria that the authority intends to adopt for the purpose of granting a reduction of the fine, but also the guidelines give guidance and indications on the content of a compliance program, and in some way on how to structure an effective antitrust compliance program. In this respect, it should be noted that there is nothing in the document clearly or particularly prescriptive. The choice made by the authority was not to adopt a template or a standard document to be followed by every undertaking, but rather to remind that every single situation has to be carefully considered in order to find the most appropriate way to achieve the very goal and the very purpose of a compliance program, that is to put in place all the necessary measures to prevent antitrust infringements. So in other words, for the authority, there is no one-size-fits-all compliance program. The authority requires a compliance program to be designed and implemented consistently with the characteristics of the undertaking and the market environment in which it operates. So basically, the authority recognized the fact that the companies are better placed to define the level of risk and the quality of the risk that they face, and to find the best way to put in place a program, an effective program. So on the basis, obviously, of the size of the company, of the characteristic of the market, of the position within the market of the company. So all these elements needs to be considered to make a tailor-made program for each company. Nevertheless, as I said, the authority outline the main features, the main elements that, from its point of view, an effective compliance program should contain, should have. And I think that this is certainly important for the business community, because there is a sort of general framework drawn up and directly originating from the enforcing authority, that has obviously the undeniable benefit of giving at least some legal certainty of what are generally to be considered as the main features of an effective antitrust compliance program. So what are these essential features or core messages coming from the authority? First of all, according to the guidelines, an effective program should recognize the value of competition as an integral part of corporate culture, and in this respect, a clear and unconditional support from the top management of a company is always required. Is a key factor, and as well as it is important to have a compliance officer with sufficient autonomy, budget, and resources to assure that the program can properly work. In addition, according to the guidelines, a program should be drawn up on the basis of a careful analysis of the antitrust risk that the undertaking faces, and this is exactly in line with what I was saying before. Should provide employees with knowledge of the principles, the basic principles of competition law. That employees should be aware of the risk that they face. A program should design and implement management processes that are capable of reducing the risk of misconducts, and should include also an adequate system of disciplinary measures to encourage, and also incentives in order to encourage compliance with the program. And finally, a program must provide with periodic monitoring and updating to ensure that the program is kept alive. And Nicola will expand on this in a few minutes, and to ensure that it is effectively capable of preventing anti-competitive behaviors. how do we achieve all this in practice? How should a company move in practice within the framework of the guidelines when designing and implementing a compliance program? I will spend a few minutes on this, but Nicola will certainly give more details when talking about how to keep alive, how to maintain an existing compliance program. But I think that there are for the designing of a compliance program, even though, as I said, there is a full flexibility, but at least there are a number of steps that are typically taken, and a number of activities that it is advisable to put in place when structuring a compliance program from the beginning, and with the purpose to follow the guidelines. So the first step is certainly, as provided by the guidelines, is certainly to properly define and analyze the antitrust risk that each undertaking faces. So the specific risk mapping is the first essential phase in building a program, and typically it goes through various steps. You start with the preliminary discussion, usually with the general counsel or top managers, in order to obtain a picture and a sufficient understanding of the business, of the organization of the business, and also to identify the employees that are most exposed to the risk of anti-competitive behaviors. Another key activity is to conduct interviews with selected employees, which are normally conducted on the basis of a tailor-made questionnaire. And these interviews are aimed, obviously, at identify the most problematic areas, the most problematic issues. But it is, I think, a very crucial phase, not only for this, but also because it is the first time for an external lawyer to get in touch with the business people. So, to put in place a successful compliance program, you need the cooperation of the business people, because you need and you need to take them on board. And so it is extremely important, this phase, because you have to build trust, to create a climate of trust with the business people. So to complete a proper risk analysis, you then usually need to go through a careful review of documents that might be relevant for the analysis that you are conducting, and the search of the documents can be done through a lot of possible means, and obviously it very much depends on the size of the specific circumstances of the case. But you can provide the employees involved with the search with criteria for identifying themselves, the documents to be collected, maybe also through keywords, that list of keywords that you may draft, or you can do it with the help, or the search can be done with the help of external lawyers and their direct involvement in the search, or even through more invasive digital forensics techniques, e-disclosure, and so forth. And all those activities are relevant to map the risk, but obviously there is another purpose, which is to allow the company to take immediate actions if required. So to immediately react, to put an end to possible problematic behaviors, to identify any additional actions that needs to be taken, even thinking about leniency application in certain circumstances. So all these initial activities is really important also for this reason. Then you normally have the phase of the initial training session, because as Nicola will say, obviously training needs to be done continuously and periodically, and it's very, very important. But the initial trainings are important because you have to spread awareness of the principles, of the basic principle of antitrust law, and it is also very important to draft and make available informative materials like an antitrust handbook with basic principles or guidelines and so forth. And finally, to complete the program, it is necessary to define and implement internal processes and systems that allow to promptly identify any possible contact likely to create a risk. And obviously, as we said before, it's important to define systems of sanctions, incentives, implement monitoring and updating systems. But I think I can stop here and leave it to you and to Nicola to expand.
Thank you. And it's a really good point. I think so often companies hope that we can give them a kind of compliance program off the shelf. You know, you must have a standard program that you've used for other people. And it's so interesting to hear how important it is to do that risk assessment process, not only to kind of tailor the program, but to identify existing risks, but also your point around building trust and how important that is from the beginning. And you don't necessarily get that if you give something off the shelf. And maybe that's a good introduction to Nicola. So Nicola Lopez is a senior director and an associate general counsel at Procter & Gamble. I understand he worked as a tax police officer before entering legal, which must come in helpful when thinking about compliance. And I know that you've got a lot of experience across different global jurisdictions and areas of the business as well. So Nicola, I'll hand over to you to talk to us about creating a compliance program on the ground.
Thank you. Thank you, Catherine. Thank you, Enrico. Thank you, Paolo, for having me. And with such an audience, I am really honored to get your attention for a few minutes. And when I was thinking about something that could potentially add something, of course, the academic side was too far for me and out of my reach to even get a try. So I thought, wouldn't it be interesting to provide, as an in-house lawyer, a perspective of those soft factors that can help having a successful antitrust compliance plan in place. And so that's where I will mainly focus. I was still taking notes after Enrico's presentation, because despite I've been dealing with this now since almost 20 years, there are a few words that can continue to strike my attention, in my experience, and I think are worth underlining. And the first one is really the culture, the antitrust culture, and using or doing whatever it takes to make the company feel competition as a value. That's the first point. And so ideally, we as in-house lawyer would like to create a pool. We want the client, our internal client, the business, to come to us and ask for compliance. And I know this is a dream because at the beginning, you are really seen as an intruder. And I very clearly remember my early meetings in this area, again, back 20 years ago and more, when I started sitting into the Monday morning business meetings held by the sales division. And the first day, I just entered the room and sat down. And somebody asked me, who invited you? And I said, nobody. I mean, we work for the same company. I'm just sitting and listening to what you're saying. But that was really the moment where they started looking at me with a little bit of suspicion. And after long silent sessions, mostly because I couldn't understand a very small percentage of their acronyms, by the way, I was trying to find the right moment and the right hook to enter into the discussion and provide both the sides of being their advocate and being their assessor. This is the big yin and yang of the in-house lawyer, and getting the balance between the two is the key to success, because they know that you are their confessor. You know that you are like the priest. You know, priests are bound to secret when they hear a confession, but they also know that if something goes really wrong, that secret will not protect them anymore. So how to gain the trust of someone that needs to be sincere with you, but at the same time help them understanding what are the capital sins that they really have to stay as far as possible from. And it's a long process. I was hearing just a few seconds ago, sometimes clients go to outside counsels and say, okay, there's good news. I heard about the Italian program. I can get a discount on a fine. Get me a compliance plan. I wish it was that easy. It takes a lot of time. It takes a lot of effort. It's like pushing at the beginning a big rock up the hill. But the good news, the encouraging news is once you have rolled that big rock over the top of the hill, it is a self-generating virtual process that still requires a lot of time and effort, but also produces a lot of satisfaction and reward when you are leading this type of situation. So getting a seat at the business table comes with a nice story, and I still remember about it. My nephew, 5 years old, he was asked, we were under Christmas time, and he was asked, please describe the best recipe of your typical Christmas Eve. And the title of his description was salmon. And the composition was 2 statements. In order to cook a good salmon, you need to have a salmon. Punto. And I mean, and every time, of course, we are laughing. Now he's 25 and more, but we're still quoting this every single Christmas. But in order to have a good compliance plan, you gotta have a compliance plan in the first place. And that's not obvious, because to get to that point, you need to have a dramatic moment in the theatrical sense of the word within your management, and you need to make this become an event. So the launch of a compliance plan is like the launch of a new brand. I'm sorry, I'm coming from a consumer goods company. That's the closest analogy. Is going to be the most important leader who will announce this, who will underline the positive effects of getting into this adventure, who will appoint you, the little lawyer in the corner of the room, as the hero, as the unsung hero, who's going to help the business, not just saying, no, you shouldn't do this, but getting the business acumen that you need in order to offer them alternative solutions. So the launch, the kickoff, and this was also another word that I was writing down. The kickoff is incredibly important, but you need to convince the business about the business case for compliance, not the legal case. It's the business case for compliance. And I have to say, I was lucky enough to work in a company that prides itself with a long tradition of compliance in general terms. So this was yet another sign, but it was, I mean, the moment when the business decided was the moment when everything started rolling down. Then the other important element is, okay, thank you, Nicola. I understand I shouldn't be doing this, but how about them? And by the way, this guy and this other guy, they told me, this is really, I mean, come on, what are you guys talking about? Everybody does it. Okay, this is the general objection that you receive from young and audacious and ambitious business managers. But you gotta have an answer to that. And the answer cannot be, well, no matter what the other things think or do, we're gonna do it our way. The answer needs to be also on the advocating side. So how do I help leveling the play field in order to reduce as much as possible the childish, it's not fair objection from your clients. Because, I mean, it's not that important to have an answer to that objection, but it affects significantly your credibility, the credibility of the messages that you strenuously try to convey in the dozens of hours that you spend in the class training people. So you gotta have an answer. And the answer is, okay, look, I'm gonna do whatever I can in order to make this something that is accepted as broadly as possible. And here comes the super important role of industry associations and business partners to use them as partners to spreading compliance culture. And again, as an in-house lawyer, this comes with additional work. Guess why? Because if you decide that you want to bring this message into a broader level, you got to make yourself available, and you got to make yourself present, and you can, and this, I mean, Enrico have been an instrument of these efforts many times on different instances, but you want to ensure that even the industry associations are guided properly to ensure that the legitimate purpose of the initiative they're carrying on and that is beneficial for the business can be conducted in a very compliant way. So, and then of course you want to pick the right places. So it's not, I guess this is part of everyone's compliance plan, but you want to decide where to play. And the where to play is comes with the screening, with the due diligencing of the industry associations, with ensuring that their sense of importance of competition is as important as it is for you, and helping them getting to a point where you would like them to be by offering solutions, alternatives, and many times legal advice. The other thing that you want to do, and that we do consistently, is to ensure that whomever represents your company in the industry association is extra competent for the specific dynamics of the industry associations, for the specific dynamics of those projects where he or she is participating, and as much as possible, you really want to ensure that whomever is sitting in an industry association is there to cover institutional and high-profile themes and topics, as opposed to specific, let alone commercial. Two ahead, one more. Okay, this again is a tip, and I have my clock running. I mean, this time I want it to be precise, and I'm bad with times. Now, get your undercover agent in the business team. This was critical for my experience. If you manage to have someone from the business that gets in his beautiful development plan as a project to be evaluated against the support to the deployment of the antitrust compliance plan, this is going to change your life. Because this is not anymore a legal project. This is a business project. And somebody's going to get rated 1, 2, 3, or whatever the rating systems you have in your company based on their ability of helping the plan being pushed. And this is going to be measured just like any other business project. So we're going to have audits, and we're going to have means to evaluate how compliant we are in the different areas that we have identified that potentially sensitive. And those are going to be self-assessed first and then assessed externally. And if something goes wrong, guess what? This is going to impact the general evaluation of how the business unit is doing, and eventually the evaluation of your general manager. So all of this helps translating the issue from yet another legal boring compliance matter to a matter that becomes embedded into the business. I mean, I think, again, my experience was extremely fortunate because I've always had fabulous partners within the business who were normally either belonging to line functions, to the sales function, or also to nearby functions, which are more easy to be drafted as partners, like F&A, the stewardship functions, HR. If you get, I mean, first of all, it's a new pair of eyes and hands, and as you know, this is never enough. But second, having someone that looks at your perspective from the business point of view is enormously helpful when it comes to prioritizing your attention and limited amount of resources. So where should I look into? Where do you think we can do better? Help me helping you, because you know what, at the end of the year, we're gonna have the self-assessment and things are not as we would like to be. This is gonna be bad for everyone. And least but not last, I mean, getting the right outside counsel inside. I like the outside inside together because this is really, I mean, the way we interpret in-house lawyering is really, we like to have our hands on. So we like to do as much as we can. And when we realize that there's something we need to go to Enrico with, I very rarely, unfortunately for him, it's an easy question. So it is intellectually stimulating, but it's also very demanding. And I think, I mean, again, I've been blessed in having Osborne, Clarke, and Enrico on my side, because you can't do, I mean, first of all, there are things that you can't do just yourself. You just cannot. And then having an additional very expert, more expert than you, pair of eyes that can help you sorting out those areas where you are uncertain. And after building a long number of years of cooperation together, even being able to replace you in those exceptional circumstances where everything is happening at the same time, not to speak about the value of having someone who understands your business, having worked with the organization for long years. It's very important, and it's an incredible tool to complement the internal efforts, actually an essential tool for that. I'm done.
Well, I wasn't going to stop you plugging Osborne Clarke, so thank you very much. But that's been really interesting, and I think there was a consistent theme of kind of partnerships there, whether it's inside the business, within your own legal team, with external counsel, and I think that kind of emphasizes what Enrico was saying around bringing this to life, and then not just being the policy that's on the shelf, but actually driving it day to day, and I think that's all really valuable. So thank you very much for that. Speaking of kind of bringing it to life, Enrico, I think we've still got some time, and it would be helpful if you could just touch on some kind of real life examples of where a compliance policy can be helpful externally, improving that you have been driving compliance.
Yeah, I think that we don't have much time left, but because also I wanted maybe to leave you a couple of minutes to make some final comments, but I think it's worth spending a few minutes on this specific topic and basically on the particular benefits relating to the adoption of a compliance program by undertakings operating even occasionally in the public procurement sector in Italy. And we can list a few of these benefits, but I wanted to set the scene first and to make a preliminary remark. It is important to know that the Italian antitrust authority in the last few years focused its enforcement action in relation to cartels on anti-competitive behaviors occurred in the public procurement sector. And I think that we can expect that this trend will not change, or probably it will even increase after the pandemic, when the role of public procurement will possibly be even more relevant than in the past. So it is reasonable to believe that the attention on public tenders will still be very high, and that competition authorities in Italy, but also abroad, I think, will be willing to investigate and prosecute anti-competitive conducts in this area. And this obviously means that the risk for companies active in bidding markets of being involved in proceedings conducted by a competition authority will still be very high and should not be underestimated. And it is in this context that I think that the proper compliance program can be particularly helpful, and not only obviously in preventing infringement, which is the main objective of a compliance program, but also for other reasons. First of all, it can be very, very useful, I think, and helpful in making sure that a company involved in an investigation, but that behaved properly, can prove that it acted in a compliant manner and that it did not infringe the law. And the recent case law of the authority, the Italian authority, shows that in many cases, being able to explain the rationale behind the choices made by a company in the context of a tender is really crucial to avoid liability. And I think that in these circumstances, a compliance program may, for example, set specific internal rules and mechanisms that would allow to show with contemporary evidence to the authority the reason why, for example, the company submitted an offer for some tenders or for some lots within the same tender and not for others, or offered different rebates for similar tenders or for similar lots within the same tender, or for example, in a case of joint bidding, a compliance program may give specific guidelines on how to behave in the relationship with a joint bidder, and on how to prove that the joint bidding with a competitor was effectively necessary to participate in the tender and therefore legitimate. And so I think that this is an important reason why it would be particularly benefit to have a compliance program for companies that operate in the public procurement sector. But there is another specific reason that to adopt a compliance program, which is linked directly to the rules on public procurement code, the Italian public procurement code, but that derive from European directives that add a further consequence and a further risk to the typical negative outcomes of an antitrust violation. And I refer to the risk that the company found guilty of a serious antitrust infringement may be excluded in certain circumstances from the participation to public tenders that take place obviously after the infringement decision. And it is important to know that in these circumstances, the adoption of a compliance program or the improvement of an already existing program may be considered as a self-cleaning measure by a contracting authority, thus basically allowing the undertaking concerned to avoid exclusion, debarment from the tender. A very final comment on, and I don't know if we have time to discuss about this, but it is a very interesting possible development in the public procurement sector that might have implications also with regards to compliance program, in the sense that it may strengthen the need to have a compliance program in place. And I refer to the ECN directive, where the directive provides that current and former directors or members, employees, or members of the staff of an undertaking that apply for immunity from fines to competition authorities may be fully or partially protected from sanctions imposed in criminal proceedings relating to criminal offenses that pursue predominantly the same objectives to those pursued by Article 101 of the treaty, and this is Article 23(2) of the directive. I think that this is extremely interesting, and obviously it remains to be seen how this provision will be implemented in Italy or in other countries. I know that it has been very recently implemented in France, but it is reasonable to expect that if the law will provide for full immunity from sanctions to natural persons, the incentives to apply for leniency will probably increase, because personal criminal sanctions obviously have always been the main deterrent, against, apart from the risk of damages, but has been the main deterrent against leniency applications in bidding markets. And so it will be interesting to see what will happen in the near future, and as a consequence, if we will have this different scenario, also the importance and benefits and the need of having a proper compliance program in place will increase, possibly. Okay.
Yeah, no, I completely agree. And in the UK, we do have criminal sanctions and the ability for directors to be disqualified as well. And certainly that sharpens the mind when you are looking for your kind of tone from the top and board buy-in, is the fact that there are these kind of criminal sanctions. And certainly I can imagine it would drive more engagements with the compliance program if there is linked kind of leniency as well. So I completely agree. Thank you, Enrico. I'm sort of aware of time. We haven't had any questions. And so Enrico, Nicola, unless you wanted to add anything else, perhaps I'll wind up there. I mean, I think the key kind of takeaway for me has been that I always think of Italy as not being prescriptive, but being perhaps clearer than some jurisdictions in what they expect to see in a compliance program. And even in that case, there's still so much that needs to be done to make the compliance program genuinely bespoke and tailored to the risks of the business, but also to getting that real buy-in. And Nicola, you talked about the importance of partnerships and being close to the business. And I think it's such a good kind of takeaway for all of us that even in a jurisdiction where you've got some quite clear guidance on what a policy looks like, you still need to take that and tailor that and make it your own for your business in order to get the proper compliance and culture that you want. But I was glad to hear that you see the kind of self-generating rewards once you've got that rock to the top of the hill, that it does come through. So hopefully that's a positive message for everybody today. So thank you both very much indeed, and thank you, Lear, for having us too.
Thank you very much, Catherine, Enrico, and Nicola. And Nicola, I want to congratulate with you, not only for the talk, that was very good, but also for your recent appointment, as far as I understood.
Grazie.
Okay, thank you very much. And now we can move to the third session of the day. Of course, Catherine, Nicola, and Enrico, you're invited to remain with us if you wish.
Sure.
I will be very happy to continue to have you.
Thank you.
On board. All right, so we can move to the third session of the day. The session will be chaired by Adrian Dirks. The topic that we will cover in this section is the retrospective analysis of competition policy. And I see Adrian there, so I can leave the floor to you and the role of introducing the speaker of this session.
Okay, thank you, Paolo, for inviting us to speak on retrospective analysis of competition policy. The objective of this session is to provide some insights on how retrospective analysis can be used to help improve competition policy design and enforcement. We have a panel of 4 speakers today. Fabienne Ilskevits of the Free University of Brussels, Peter Omosi of the University of East Anglia, and Tommaso Duso of DIW Berlin, as well as at the Technical University in Berlin. I'll first like to introduce our first speaker, which will be Fabienne Ilskevits, who is Professor of Economics at the Free University of Brussels. Previously, she held the position of Principal Advisor at DG Competition, where she was responsible for the ex-post economic evaluation of competition policy. She has also co-edited a book on the EU experience with ex-post economic evaluation of competition policy. So what I'd like to do is I'll raise some questions to the different panel members. The audience will also have the possibility to raise questions through the Q&A button. And at the end of the session, I will select some of the most relevant questions, and then I'll pose them to the panel. But let me first start with my question for Fabienne. The question is, what are the main lessons that you draw from your experience in ex-post evaluation at DG Competition? More in particular, how can one improve the impact of ex-post evaluation for competition policy enforcement and policy making in the future? Fabienne, please take the floor.
Thank you, Adrian, and thank you to Paolo for having invited me to this session. In fact, I would like to make 3 points. First, DG Competition has mainly used ex-post evaluation for advocacy purposes, and this is important. As we have seen in the previous session, it's important to be able to justify the actions taken. It has also used the competition ex-post evaluations to improve the quality of competition policy regulation within the context of the better regulation agenda. But to improve the impact of ex-post evaluation activities in the future, I believe that these activities should be more used for setting priorities and to improve the quality of competition policy enforcement. Regarding the setting of priorities, the customer savings can provide interesting results. The calculations of the customer savings at the EU level show that a relatively limited number of interventions account for a very large share of the customer savings. And on the other hand, there are a number of other interventions which account for a limited share of these customer savings. Of course, the customer savings only provide a partial picture of the impact of competition policy interventions because they don't measure the non-price effects or the deterrent effect of these interventions. But if we observe that some interventions provide only limited customer benefits and on top they do not have important deterrent effects, then one may wonder whether we should invest resources in these interventions. And that's how I see that ex-post evaluations can contribute to feed the discussion about priority setting within competition authorities. Regarding the quality of competition policy enforcement, what can observe that in general, in-depth ex-post evaluations only cover individual decisions. And therefore, it's difficult to generalize the results from these ex post evaluations because they are by nature case specific. And then an option to improve the impact of ex post evaluations for competition, to improve the quality of competition policy decisions would be to use a simpler method, but covering a larger sample of decisions and, for example, checking whether the assumptions made at the time of the decision turned out to be true ex post. My second point is that ex post evaluations require time and resources. You need a very well-trained empirical economist. You also need an infrastructure to collect, to store, to process the data. Despite these requirements, I believe that ex post evaluation activities are very useful for competition authorities because they allow these authorities to draw lessons from their past experience. However, competition authorities have limited resources and therefore they are relatively reluctant to divert resources from enforcement, which is their core business, to ex post evaluation work. And that's the reason why I think that ex post evaluation project should be very well selected and impactful. Another problem with the limitation of resources is that it is more difficult to integrate the case teams in ex post evaluation work because they are very busy with their case work. And therefore, it's more difficult to really develop an evaluation culture within competition authorities. And in this respect, one option would be to create mixed teams involving internal experts, but also external experts having very good knowledge of state-of-the-art methodologies and which are also more independent, which can contribute to increase the credibility of the ex post evaluation work. And finally, my last point is that I think that it is important to improve the cycle of ex post evaluation and to start thinking ex post evaluations already at the time of the decisions. Why? Because a key for successful evaluation is to have a good data. And so if you need to have good data, you already need to think about the strategy of the collection of the data, and even you can already start to collect the data at the time of the decision. And in this respect, the market participants can also provide useful data for ex post evaluations, but they may be reluctant to do so. And therefore, I think that it would be useful to provide more legal powers to competition authorities to request for such data. And finally, I think that it would be also extremely useful to give access to non-confidential data to academics, because this could stimulate further the research in ex post evaluation.
Okay, thank you, Fabienne. I just have one follow-up question. In light of your experience within the European Commission, what would you say are the main gaps in terms of the ex post evaluation work done over the past years?
Okay, so I see 6 areas for further work, and I will be relatively rapid on that. I think that the first one is certainly to try to improve, as I have already mentioned, the impact of evaluation on the quality of future decisions by covering a larger sample of cases. My second area of research would be to make more ex post evaluations covering abuse of dominance cases and other anti-competitive agreements, because relatively limited work has been done in this area. Third, I think that it would be also useful to continue the work on the non-price effects of competition policy interventions. A lot of work has been done on the price effects, but relatively limited work has been done on price effects. For example, understanding better the impact of competition policy interventions on innovation would be extremely important, especially in the context of the digitalization of the economy. Fourth, I think that what would be very important is to know more about the deterrent effects. There is an agreement in the literature that the deterrent effects are important, but we know, in fact, we have relatively little information on the size of the deterrent effects. The only information that we have comes from surveys, giving information on the number of deterred cases per number of detected cases, but these surveys are 10 years old and they cover only a limited number of EU countries. So we certainly need more work in this area. Then I think that it would be also important to continue to work on the macroeconomic impact of competition policy, to have a broad perspective, and that's also something which has been highlighted in previous sessions. I think that DG Comp has been a front runner in this area, but work should be continue, especially because it's surprising to see that a lot of work has been done on other policies having a big impact on the conditions of competition, like trade policy, internal market policy, and so limited work on competition policy. And finally, my last area for further research is to be better able to compare the performances of competition authorities. And in this area, Lear and Paolo has been a front runner, and this is a very complex and difficult exercise because you need to find the good indicators for the performances of competition authorities. Also, it is an exercise which is politically sensitive, and you should not end up in a beauty contest, but I think that it would be also a worthwhile exercise. And finally, my last word is that I think that ex post evaluation will be even more important in the future. Why? Because we see that competition policy needs to adjust. It needs to adjust to the challenges associated with the globalization of the economy, the digitalization, and more recently, the impact of the COVID-19 pandemic. And in this context, we see that there are some arguing in favor of a relaxation of competition rules and others considering that we need to reinforce competition policy enforcement. So I think that this is an important debate and that ex post evaluation should feed this debate with good evidence.
Okay, thank you very much, Fabienne. We have to hurry on to the next speaker, which will be Peter Ormosi. Peter is a professor of competition economics at the University of East Anglia. Before joining academia, he worked for the Hungarian Competition Authority and for the OECD as well. His research covers various topics in law and economics, including the measurement of cartel detection and deterrence, and also the ex post evaluation of merger decisions in the EU, which will be the topic of his presentation today. Now, my first question to Peter is, what are the main conclusions that you draw from the merger retrospectives that you have looked at? And what areas deserve further examination? Peter, I give you the floor.
Thank you, Adrian. It's really fantastic to be here, and thank you, Paolo, for organizing this. I know merger evaluation and retrospective studies are very close to your heart, so you yourself could be lecturing us about these issues as well. But here's my perspective, just very briefly, just to rush through a few points, and just to say that we've rehearsed these questions. Therefore, I have slides to present. To give a little bit of a background, there's an increasing body of ex post merger studies, and it's increasing, but it's already reasonably large. And most of these studies look at the price impact of mergers. Now, probably I should put it up front. When I say retrospective merger studies, I really only refer to the studies that were done after the merger, using some sort of causal inference econometric method, focusing on specific cases. So we're not talking about aggregate studies of many mergers altogether. You can think of these as case studies. And there's a large number of these. The US ones have been reviewed in a sort of meta study type context, by John Quokka, and then we did a similar review for EU studies for the European Commission, and then later on with my colleague Franco Mariuzzo, we looked at, rather than looking at case level estimates, we looked at market level estimates to kind of try to tease out even more information from these studies. And even since we've done these studies, there have been many new evaluations. So it's really still a growing field. In terms of the main lessons that we've learned, if I just start with some of the smaller but rather important points, it's useful to have this large body of evidence. First of all, you can actually derive some average impact of mergers, so to say, and that might give you some vision of how healthy your merger control is. But I think more importantly, this body of evidence is useful to dig into the heterogeneity across these studies, and Fabienne already referred to this, that these individual studies often reflect very different markets. But of course, if you accumulate enough evidence for each market, then of course you start creating a nice corpus of evidence to draw on. The other thing we've kind of learned is that interestingly, there's much less focus on the dynamic impact of these mergers. So these are all kind of static estimates to the extent that it tells you what the price, how prices changed, say X years after the merger, but we don't really know how it got there and how it evolved afterwards. Whereas we know, of course, the price don't remain stable, and that sort of dynamic impact would be very useful. There's much less on non-price effects, as Fabienne already mentioned, but I will have a slide on this in a second. And of course, most of these are about price effects. So just to give you a very brief snapshot of what we've came to with Franco in our sort of meta study, looking at the merger level or whether the market level estimates. If you just want to get an absolute total, so on average across these many mergers, or even more kind of markers that were estimated, what was the impact? There's a significantly positive impact. So I'll come back to this, what it really implies in a few minutes. But there are many other things that to learn from this table. One is you can see that some industries are more represented than others: airlines, petrol, hospitals especially, mainly driven by the fact that this is where most data is more readily available, and largely driven by American studies. There's also things that stand out. For example, hospital mergers, even when you look across the averages, these are very large positive estimates, price increase estimates. And of course, if anyone who follows the kind of health economist discussion about hospital mergers, they have been kind of ringing the alarm bells about these mergers, that they are not good for competition. So there's a huge wealth of information to get from these previous studies. Now, to move on to non-price effective mergers, there is something that's already happening on innovation. We have done a study for the European Commission. There's something on product variety, which of course two of the authors are here in this panel or attending right now, at least two. There's been stuff done on flight frequency and so on. So it's kind of, it's still a nascent part of the literature, but it is happening. Now, I don't know, Adrian, do you want me to say a few things about what I see as kind of the promising new avenues, or is it something that, do you have other questions or anything?
I've been told we are a bit short on time.
Okay.
So I would suggest I go to my second question. Okay, and that's actually a bit a broader question, which deals with this ongoing debate internationally about the increased market concentration and rising markups worldwide. And I think you've looked at merger enforcement and the impact of mergers. And my question to you is there any sign of under enforcement and merger control in Europe or worldwide? Can you say something about that?
Yes, of course. I'll just flip back to this slide. Yes, if you look at these studies, you know, these are mergers that happened. So none of these were blocked mergers. These were either intervened by competition authorities or there was no intervention. So if you look at this and you find that, well, on average, there's a price increase, it kind of would tell you that, well, maybe merger control is not really doing perfectly what it's supposed to be doing. And that's why we have these cases to kind of slip through either unintervened or even if there's an intervention, it's not effective enough. If you look at the Clarke study, for example, it finds that in the US, they're good at finding where the intervention should be, but maybe the intervention is slightly undershooting, and that's why he's finding a positive price change after mergers. However, there are a few caveats here in terms of generalization of these findings. One is, of course, the selection issue that which markets are being looked at. Typically, researchers and authorities, if they do a study like this, they're more interested in the sort of marginal cases, or where there was some kind of interesting issue, or where there was some kind of question which wasn't so obvious. So these might not be representative of the total population of mergers. The other thing is, as I've already referred to, these are sort of static estimates, typically most of them looking at the impact within 2 years of the merger. Of course, one could argue that it takes longer for markets to self-correct. And I'm not implying that that is the explanation. What I'm saying is that if we want some generalization about the effectiveness of merger control from these studies, then we have to be aware of these caveats.
Okay. Okay. Yeah. Thank you very much. We have to carefully assess these questions, and this, I'm sure this debate will continue in the future. I'd like to now go to the third speaker in the panel. It's Tommaso Duso, who heads the Firms and Markets Department at DIW Berlin. He's also professor of empirical industrial economics at Technical University in Berlin. And his research interests include the ex post evaluation of competition policies and also product market regulations. Today, he will report on some of the work he has done in evaluating the modernization of state aid policy. And there's two questions I'd like to raise with Tommaso. First, how would you assess the impact of state aid and state aid control on competition, especially following the state aid modernization program of the European Commission of a couple of years ago? Please, Tommaso, go ahead.
Yeah, thank you very much, Adrian, and thank you, Paolo, for having me. It would have been nicer to be in Rome, but the sun is also shining in Berlin. So the state aid, I think, and state aid control, I think it's an area that is extraordinarily important and is an area that attracted too little interest until now. It's usually important because state aid involves a great amount of public resources. So we have some estimate from the scoreboard, state aid scoreboard of, say, for 2018, 120 billion euros. So it's a lot of money. It's also very important because state aid is something that is at the interface between competition, industrial policy. So it requires a even deeper understanding of the goals these instruments aim to reach, and it's much more political. So I think that it's even more important to have some fact-based information or a fact-based assessment to weigh against different political goals, which are absolutely legitimate, right? So, so where do we stand? There is, yeah, we are at the beginning. I think I think that the evaluation of state aid control is underdeveloped, partially because monitoring has been bad, is changing. Has been bad in the sense that, from my experience, neither the Commission nor the member states really felt responsible to collect precise data about how they spend the money, let alone how this money affected some outcome. So as a consequence, data collection is very patchy. So this is something that Fabienne also mentioned, and in state aid is not different. Often they are very aggregated. Even this fantastic state aid scoreboard that we have been using in some of the studies is actually let's put it nicely, is not perfect, right? So, things are changing. I think that the modernization of 2014 really helped, introducing more transparency, and but still there is a use date for better data, and also for the development of specific methodology. Now, the modernization so a very good side, I think, of what is happening in Europe is that the Commission understands this. I think the effort started in 2012 that ended up with the modernization package in 2014, I think was a very important step. It led to a more economic approach also in state aid. It understood the need of data and evaluation. So there are new requirements since 2014 on ex post monitoring for the member states, requirement to be more transparent, and also the Commission is required to conduct evaluation over time, and that led to a fitness check that started in 2019, and this is where we have been working a lot over the past 2 years. So we, as the IW, we have a fantastic set of partners, including Lear, and we evaluated their guidelines. It's a different kind of evaluation. So we look at guidelines for regional aid, guidelines for state aid to promote risk finance investment, aviation state aid, and state aid for environmental protection and energy. So, and that is where we stand. Maybe we can talk a bit about what this evaluation brings.
Okay, thank you, Tommaso. As you mentioned, you have been involved in doing some retrospective analyses of competition rules and regulation, which is something complementary to what the Commission had been doing usually, which is to conduct public consultations of stakeholders and revise its rule on that basis. So what would you say is the value added of these retrospective analysis for policy making for the European Commission?
So maybe starting, I think the public consultation are very important. So we had the discussion in the previous section about technocracy and so on. So I think it's very important to have stakeholders bringing their views in this important process, right? Which is a institution setting, legislation setting process. But clearly, stakeholders have their views. So I think that one of the the major advantage of this assessment and retrospective analysis of say guidelines and policies is that you can have a more independent assessment, and this is particularly true if you have academics also that put their reputation at play with this. the other advantage is most of the time these assessments are more quantitative if compared to consultation, and so it's, as you say, so this kind of assessment is also complementary to the kind of assessment that Peter was talking about. So we have a lot of case studies. So we also did one actually in a project for Fabienne and yourself. I think it was one of the best case studies that I ever managed to do, because the quality of the data was great. It was about state aid for broadband. So not only me, but the entire team at the DIW. So that was great. But I'm not sure what the policy impact of this one case study was. When I think about the evaluation of broader things like a guideline, I think that the main advantage is that these kind of evaluation are really looking at the broad picture, right? So they are looking at the rules of the game. And therefore, the potential for the policy impact is much larger than in simple case study kind of evaluation, right? So, and indeed, so that was my experience. So the study that we did on the regional guidelines really informed the choices of the Commission to change some things in the guidelines. So, and maybe as a very, very last point on this, I think that these impact assessment are also more important because not only they have a more immediate policy impact, but also that this policy impact is much more long-standing, because rules and institutions, which are the rules of the game, are only changed rarely, right? So I think that having this evaluation right can really have a very important role in designing institution in the best way.
Okay, thank you. Thank you very much, Tommaso. I think you rightly stress the importance of making sure that our retrospectives or ex post evaluations have a real broader impact on policy making. And this naturally brings me to my last speaker, which is Thomas Dijsenhofer, who has recently been appointed as the principal advisor in DG Competition for the economic ex post evaluation of competition policy. Before that, he has a lot of experience in merger control. He used to be head of unit in the merger control unit responsible for the basic industries, manufacturing and agriculture. And so he will be speaking about his plans for ex post evaluation at the European Commission, forward-looking. And so my first question, and then I also take a question immediately because we have to finish in 5 minutes. My first question is, since taking office, what would be the main challenges and opportunities that you see for the development of ex post evaluations? And let me add a question from the Q&A from Michele Molteni, who asks a question both for Thomas and Fabienne. How is the Commission planning to ex post evaluate decisions based on innovation consideration, such as reduced R&D? So perhaps you can address this question from the audience at the same time. Thank you very much.
We can't hear you, Thomas.
Thomas, you probably have to put on your microphone. It's at the bottom left of your screen. You go down.
Can you hear it?
Yeah, now we can hear you. Yeah, we can hear you now.
Apologies, there was a technical glitch. Good afternoon, and thank you for having me. It's an honor. I'm not a usual guest. I'm a newcomer, so I'm very happy to be here. Let me try to be brief in these 5 minutes and very briefly speak about the opportunities and challenges. I like to start with opportunities and then say a few words what I actually intend to do over the next years, and then in that context say something on innovation. I like to start with opportunities. As I said, I think the first opportunity is to take over from Fabienne and Adrian, and have Adrian with me, because that's kind of standing on the shoulders of giants, and finding a house well in order and with a lot of work done over the last years, which will continue to be the foundation of everything what I will be doing. So I think that's a wonderful position to be in, to come at such a moment into that position. The second opportunity, I think, is that Executive Vice President Vestager is very keen on ex post evaluation, and she's an economist. She suffers, I can tell you, if the debate is based on some anecdotal evidence, and she likes data. And so she is very much in favor of a push on ex post evaluation and on having better data. Third opportunity I see is that I come at a moment when there is a very rich and vibrant academic literature on this topic. We've been speaking about the study on innovation, merger retrospectives. We see work on macro. We see work on state aid for the first time. So all of this is going further. I would call it, I'm a skier. So my analogy would be there is deep powder skiing going on all the time, innovation in the academia, and it's very exciting to join at the moment when there's so much innovative work going on. And linked to that, and I think that's the last opportunity, last point which I want to mention, is that there is also a very exciting debate on competition as such outside, and that debate has the element of the Siemens Alstom, are we too tough? What about industrial policy? But it has the debate on digital. Are we too soft on these digital giants? There is a debate triggered by this fantastic new literature, which started with the articles by Furman and Orszag from general economists who start to get very interested in competition. And you have the Eckouts and De Lucker and IMF starting to write about competition. So there is a general excitement, and you feel that there is change in the air, and you start to read about topics which competition economists hardly looked at a few years ago, like inequality and the effects on labor markets. And so it's intellectually and from a policy point of view very exciting. The challenges are, on the one hand, the ones that were always there, and I think that is something which is not said often enough, also by the professionals in the field that you represent, is that to evaluating competition policy is very difficult. It is the action that causes the harm is hidden. The harm itself is hidden, is not observed or not directly observable, and the benefits of the remedying action is not observable. So we are not in road safety. We are not in murder prevention. It's very difficult to do statistics. It's all not visible. And the second huge challenge is causality. So how do you link in these very living organism that markets are, where many things happen at the same time and in parallel? How do you see the links between cause and effect, and how do you isolate the effect, for example, of one of our interventions? The second challenge, Adrian mentioned it, and also Fabienne mentioned it, is the key challenge is resources. We are unlikely to have more resources in the next years, and in case of doubt, enforcement and policy will have to have priority. So we have to be very smart about how we're going to do it. I think Fabienne mentioned the key point. Think in cycles. Bring the evaluation already in the case closure form and foresee it already. A bit like a doctor does the operation and has already a date with the patient 3 days later to inspect how the operation went. That has to be built into our work from the beginning so that we get better data and more data. The third challenge is a very personal one. I'm a lawyer, and I'm going into a field where there are a lot of brilliant economists. And so for me, I'm trying to understand regressions, at least how to read the outcomes of regressions, not how to do them. Not going to be to manage that very soon, or to learn Excel. And I can announce they're making progress. I'm doing pivot tables already on a data set that Tommaso produced with this institute. So I'm having great fun there. But more seriously, that's obviously a handicap, but in my experience, it's good to have lawyers and economists working together on these issues. We can complement each other and strengthen each other's experience on this. Now, I don't know whether I can say 3 words on the program. Paolo, what is the time?
My understanding is we have to be quick, but Paolo is the boss.
The other session is pushing. So if you can, just in 1 minute summarize the program, that would be great.
So, yes, no problem. I will be very fast, and it's actually quite easy. We want to do around 3 axes: impact measurement, customer savings, and the macro impact. Evaluation studies. We want to do big evaluation studies, the one that Fabienne mentioned. Perhaps simpler in terms of methodology, but larger sample of cases to really draw policy conclusions. And there will be a first study out during the next weeks and another study before the summer. I'm calling you all, watch what's coming out. We need good people to do this study, these studies. There will be more studies during this year on another area. So the areas will be mergers. There will be one on pharma. There will be one on antitrust. Larger studies, that's one key area. And the last thing is capacity building in DG Comp. And there we want to strengthen investigative powers, academics in residence that Fabienne has been mentioning, strengthen our network with academics. Next year, deterrent effects. We want to work on deterrent effects with our study again, with survey. We may do something on merger remedies, something big. So there is quite interesting times ahead. And I call you all to help us so that this will be a joint project between academia and the Commission, and we'll all contribute in these exciting times to better competition policy. Thank you very much for having me, and apologies for being too long.
Yeah. Thank you, Thomas, Tommaso, Peter, and Fabienne. I think you gave a good overview of the broad range of retrospectives that are being carried out, mergers, state aid, and other domains. And thank you very much for being here today. And I'll give the floor back to Paolo for the last session of today. Thank you very much.
Thank you.
Thank you very much, everybody. Sorry, I know that time is the strongest constraint for always, and there is a good reason now, because we have a very interesting session that is coming up, and the session is matched by our legal partner, Parr, and I'm very pleased to welcome Jeremy Fleming-Jones, that is going to moderate a debate in which we take up policy and politics, if I understand correctly. And we go back where we started this morning with discussion about the DMA and its impact on competition policy. Okay, so Jeremy, the floor is yours.
Thank you very much, Paolo. Yeah, well, I'm delighted that we have a couple of the leading players in the construction of the Digital Markets Act, which is currently in mid-legislative process. Dr. Andreas Schwab, MEP, who is the rapporteur for the European Parliament's Internal Markets Committee, and Olivier Guesson, the Director General of DG Comp, which proposed the policy last December. And we only have a brief half hour, so the format is going to be to get some ideas from Olivier as to what the original inspiration for the policy was, and then move over to Andreas to give some update on where his committee feels it wants to see some amendments, and then we'll go back and have another discussion to see what progress the paper is currently making. But perhaps I can move straight to Olivier to sort of set the scene, as it were, on the Digital Markets Act, on the purpose for it, and then we can move over to Andreas. So over to you, Olivier.
Good afternoon. Can you hear me loud and clear, Jeremy?
Yes, absolutely.
Okay, excellent. Good afternoon, everybody. Well, you asked me to set the pitch, and really at the origin, at inception, there was this broad policy question that we've been asking ourselves for several years now. How can we ensure fair and open digital markets? This is an important question. It's not a new question by any means. We've been dealing with it one way or the other for a long time now, ever since the first Microsoft case 20 years ago, more than 20 years ago, in the early 2000s. But also, I mean, along the way, the P2B regulation and the various Google cases, etc. So over the years, all these elements have brought more and more arguments to the table as regards why digital markets may need to be regulated. It's a bit the similar process that took place 25 years ago with telecom markets, if you remember, and that led to the telecom framework back in 2003. So this time it's the DMA that is our proposed reply to this question. And of course, we need to get it right. We need to get it right not only because all eyes are on us, I would say worldwide. We will have an OECD session on this in December. We're discussing it with our major partners, but also because this piece of new legislation will set a new standard on European values and how best the innovation can occur in an environment where everyone has the opportunity to innovate. So we see that the DMA has launched a global debate on that topic, and we are very happy to see that. So leaving aside a long explanation of what the DMA is about, which probably you already know, I just want to convey two messages to kickstart this discussion. Well, first, competition enforcement is a key piece that has been instrumental building the DMA. Some of the DMA obligations, such as the MFN bans, or the bans to use business users' information to compete against them, these have clear competition backgrounds. They're rooted in 20 years of enforcement of Article 102. And of course, this has a clear consequence. That is that the DMA and competition law are and will be going forward complementary. And this is why the proposal in Article 1.5 and 1.6 makes it crystal clear that competition law remains fully applicable, including Article 102 of the treaty and the similar national provisions. Of course, we've heard some isolated voices arguing that this will be the end of 102 cases. That will not be the case. I can tell you there will still be plenty of scope for enforcement of EU and national competition laws in the digital sphere in general, but also around the provisions of the DMA. And of course, there will be cases which will fall squarely also within the scope of the DMA, where enforcement of 101 and 102 would most likely be unnecessary. But there will always be cases which are not covered by the DMA, which will continue to require vigorous enforcement of antitrust rules, and maybe will feed into the DMA at a later stage. Because these markets, by definition, have a changing nature. And that means that a number of new anti-competitive practices and conduct will appear, like it happened with Google's anti-competitive self-preferencing some years ago. So, and that brings me to my second message. While competition law has shaped and will continue to shape the DMA by means of its updating mechanisms, the DMA should not be seen as a competition law tool because it is a regulatory tool. So it's a cousin, it is not a brother. It's complementary, it's not the same. And that is because, first of all, competition law is not the only source for the DMA. Unfair practices, consumer protection, to a certain extent, data protection, all have room in the DMA, even if it is very close to competition policy and the rest of it is rather covered by the DSA. But these borders are not completely clear, and they will never be. So there is also a bit of something else than strictly competition law in the DMA, and that is good. And secondly, the DMA is not strictly speaking competition law tool because of the very way it works and the very way it is built. It's an ex-ante legislative tool. It is a harmonization tool. It provides solutions for contestability problems and unfair practices linked to gatekeepers with EU relevance, and this ex-ante nature is all over the proposal. The DMA does not require the case-by-case investigation that each competition law inquiry entails, and that's good, and that's one of the big advantages of the tool. And the designation process of gatekeepers is based on clear criteria, quantitative criteria, creating a rebuttable presumption, as well as narrowly defined qualitative criteria, and that's very different from the definition of dominant players in Article 102. And the DMA obligations and prohibitions are built to be self-executing. So no discussion on the effects, efficiencies, or objective justifications, which is also a major difference with antitrust. And finally, the reasons for suspension in Article 8 and exemptions in Article 9 are very narrowly construed. So with these two messages, I hope to make clear to the audience that while the DMA is designed as it is designed to tackling the known most harmful behavior that we have been able to identify through competition instruments by the most systemic gatekeepers. But leaving competition law itself untouched so that it can deal with practices beyond the narrow catalog of the DMA obligations.
Okay, thank you very much for setting that stall out, Olivier. Andreas, if I can come to you, we know that you have this rather fat report with 130 amendments sitting on your desk, heading towards the committee on the 21st, I think, of this month for approval. And I just want, you're not going to have time to take us through all of those proposals that your committee is likely to make. But I wondered if I could ask you, if you had 1 minute to grab at the things that you think to be the most important that you want to see changed in the Commission's proposal, what would you flag as the must-have changes that you think the Parliament is going to demand?
Well, Jeremy, thank you so much also for giving me the chance to speak here. I think the Commission, that's not always so evidently to be said, has done an excellent job. I couldn't say now that there is nothing to change. I think there is some clarity, some further clarity needed. And in a minute or in a nutshell, I would say it's about that we have to beef up the role of the European Commission, that this time has a bit been too modest in the proposal when speaking to gatekeepers. And at the same time, I think also that we have to focus a bit the Commission's work on what a gatekeeper is, because they will have not the chance, in addition to competition policy application that will continue to be applied, as Olivier has rightly pointed out, they will not have the chance to spend too many people with too many companies. So to start with, I think we have to be a bit clearer what a gatekeeper is. We have to sharpen a bit the definition. And we have to beef up the role of the European Commission in an enforcement environment that there are also member states, authorities that have been helpful in the past as well. And all this has to be done without destroying innovation, without being negative on existing companies in the market, but all the time being positive about more competition, more contestability, helping also the gatekeepers to become better offers for consumers, for users, for businesses, and not being limited at borders, but being a real global tool that should make digital markets better in general. For sure, this is a dream, but we will try to get as close as possible to that dream becoming a reality in the legislation. Therefore, I hope that I have been giving you a 1 minute a short nutshell about what I think we should achieve.
I mean, if I could just pick you up on a couple of the amendments which we understand are sitting in that report. I mean, it seems to me that you are looking to give third parties more purchase on the process, and also to create a proposal for a high-level group, sort of digital enforcers group, which would sit somewhere within the existing proposal for another digital advisory council. Why do you think that there is a need to give third parties more powers in relation to the, I mean, if you want to strengthen the Commission's hand, wouldn't that weaken it?
No, definitely the key message with my report is that we want to keep the Commission as the key driver and the ultimate decision-making authority on that all. That is somehow disputed in member states, not all over Europe, but in some member states, but this is kept. But let's imagine that the gatekeeper doesn't stick to some obligations. Wouldn't it be wise that people that are living in Lisbon can go to a Portuguese court to get damages? Why do they have to go always first to the European Commission? And therefore, I've been mentioning, for example, national courts also being able to apply the principles that are there for the gatekeepers under 5 and 6. And as Olivier has pointed out, they should be self-executing. Therefore, no question from my point of view, why not also giving national courts and private people a chance to enforce these rules like that. And in relation to the authorities, I think we have people working in Paris. They do a good job. We have just recently seen it with Google. We have people in Bonn and in other countries and towns, and they should not be lost for that process, although obviously it's the European Commission who is at the heart of the action. And therefore we have added in Article 14 or 15, for example, them to be also helping the European Commission with market investigations.
Okay, thank you very much, Andreas. I mean, Olivier, I wonder if I could come back to you and ask you what you feel would be the impact of diluting, if you like, the processes of the DMA and giving national courts a broader role, giving a high-level group of digital authorities more say in the processes. Do you think there is any? I mean, is that something that would be welcomed by the Commission?
Yeah, well, I mean, I don't. First of all, let me be clear. I don't think that the proposal of Andreas is diluting the role of the Commission. And from a point of view, it is very welcomed. And he was kind enough to commend the work of the Commission. I have to say, I and my colleagues were quite impressed by what Andreas was able to put together in such a compressed time. Because it's not only that it's a good report, that it's a very quick report as well. And I will come back to this, but frankly, for example, that for these obligations that we have designed to be, we call it self-executable. Well, nothing in this world is self-executable, but they're quite clear. I mean, frankly, gatekeepers should know what they cannot do. If they do it, however, I agree with Andreas. Why is it that you would have to go to the Commission? And maybe we have many other cases to deal at this time. Maybe it is longer than it needs to be. And you couldn't go to your national court and say, well, listen, it is written here. They cannot do it. They do it. Please make it stop. I don't see it as a dilution, frankly. There are many aspects I like in the report of Andreas. Let me maybe emphasize a small number. And I will start with the aspect I like much, is that it preserves the structure of the DMA. And of course that will, because what we want is we want to have something that is effective, and we want to have it adopted as quickly as possible. That I think is the goal of Andreas, is our goal, and I think is the goal of the Council. And that of course, if we had wide divergences about how the text itself should be structured, that wouldn't have helped. So I think that's very, very welcome. And while preserving the structure, in my view, it improves the DMA with mechanisms, and we just discussed it, that improve its efficiency. As Andreas said, I think it was a good proposal from the Commission, but of course it could be bettered, and I think the report betters it. Sorry. For example, I very much support decoupling the quantitative rebuttal from the qualitative designation test in Article 3.6, which is something we hadn't thought about, and I think it's a very welcome innovation in the report. Secondly, a rebuttable presumption is of little use for both companies and regulators if companies need to engage in a mini competition case with efficiency and so forth every time a company wants to rebut the presumption. So while we are strong advocates of the need for a rebuttable presumption, the possibility for a company to rebut the presumption should not become an administrative obstacle or even worse, a means to be used as a delaying tactic. Third, maybe the quantitative criteria are strong indicators of gatekeeper power. And once we set those thresholds, there is a political choice. Those criteria should be the main indicator of the presence of the gatekeeper. So, of course, subject to the security valve of the rebuttal presumption of the qualitative designation, the market investigation mechanism were appropriate, but that is preserved, and we like it. I have to say personally, and maybe to the risk of surprising you, I like and I welcome the involvement of national authorities. Upstream and maybe also downstream. We need to discuss this with them. Never forget that we have two constituencies, and both are valuable to us. We have the constituency of sectoral regulators, and they know these markets. They have a lot of knowledge to bring to us. And we have the constituency of NCAs, of national competition authorities. And then they have the right, with regulation number 1, to trigger a 102 investigation anytime they want. Some of them are even much more far-reaching rights by virtue of the national legislations. Germany, and you saw that they do not shy away from using them. So not only we will need their help, but we also will need to coordinate if we want to have a global enforcement that makes sense. And you cannot coordinate with people that you leave outside of a mechanism. So I think it is actually extremely welcome to find a consistent and sensible way to integrate national authorities in that work. Fourth, we are extremely appreciative of the work that Andreas conducted, because it's clear that he understands the choices made when designing the DMA. When putting together the proposal, we have sought to strike a balance between flexibility, speed, and legal certainty. And of course, it's like any balance. There is not only one univocal way to do it, but it's important to keep that in mind when you make any amendment. And we believe that a core element of this is to preserve enforcement at EU level, because what we're talking about here, far and foremost, are very big beasts, the practices of which are likely to be deployed on the whole of the EU, and actually broader than that. And therefore, rather than having a patchwork, we need to keep the possibility to catch it into one single decision. And that doesn't do away again with the fact that it's very welcome that national courts, when there is a clear infringement, can put an end to it. So there is a balance to keep here, because the risk of fragmentation still exists, and it may increase, for example, if national laws would be allowed to go too far and to contradict each other or contradict the DMA enforcement. So there is a fine balance to find here. So that's the value to have a regulation, so a legal text that is directly implementable in all member states. So as such, we see that we should further work together with Andreas and the Parliament. to make sure that we achieve a kind of coordination with national authorities that brings about further added value without jeopardizing the harmonization effect of the DMA or increasing the coordination challenge. And I think we are very well on our way for this.
Great. Well, Andreas, maybe that's a good moment to come back to you and ask you a little bit about the process from here on in. Your committee is leading on it, but there are several others in the Parliament which are having inputs into your lead report. I think that you've set a deadline for November with the aim of getting plenary agreement, but can you tell us a bit about what the procedure is likely to be and how soon you might get to trilogue stage?
Well, I mean, it's very easy. We want to close that file under French presidency, because even if we are very successful and the French are already very ambitious and we are grateful to them, the law will enter into force only in 2023. So that means since our resolution in 2014, it will be 9 years later that we come up with that law. And I think we should not wait any day longer. We should try to be as fast as possible, because we have seen with recent decisions in the European Commission in the area of digital markets that the DMA comes already quite late. But still, we will try to make it possible. And for that reason, we have to vote in the European Parliament in the plenary at the end of that year. That will be the latest moment possible, so just before Christmas. And then 2 weeks before has to be the vote in the Internal Market Committee. 2 weeks before that, there has to be the vote in the relevant committees that can make opinions with a stronger recognition. And then 2 weeks before the other committees. So we'll have to vote, let's say, in the Parliament between October and November. And then in the plenary in December. And that's our driving, let's say, aim. And like that, we will work fastly, quickly, and concentrated. And I'm sure that there will be elements of discussion that will come back. It's the quantitative thresholds that I have a bit adapted. I think legislation should be general and abstract. So there should be no special company, the object of the legislation. It should be general. And I believe that 65 is a number, Jeremy, that you may consider for your pension, but not, let's say, if you speak about gatekeepers, you speak about 100 or 50 or 75. So I think it's just a common sense approach, but it's a topic that will be discussed a lot, because every country, every politician has some sort of gatekeeper in the mind when speaking about that threshold. But as Olivier has clearly said, the qualitative criteria remain. The Commission remains free to designate as a gatekeeper whatever company they may find as a gatekeeper. Then there will be a discussion about member states' roles and inclusion. I think the balance that we have been able to strike is quite fair. But still, some smaller countries are scared that national authorities could be too important. The bigger member states might be scared that their national authorities, that their importance is too much limited. We have to strike that balance. And then we have to work, and I'm very happy for all colleagues to invest as much intelligence they have on this to improve the text word by word. What is a core platform service? Are voice assistant platform service? Are they part of browsers? Are they part of search engines? This is all technical, and every colleague, every committee is welcome to improve the text. And my measurement, my judgment will always be, is it improving the text or not? And like that, we will work together in the European Parliament. And I'm quite confident that we will have a good outcome because colleagues are very much motivated.
Great. Thanks, Andreas. Olivier, Andreas, they're making a prediction that the first cases would not be able to come before 2023 at the earliest. It raises a question about enforcement under the existing tools. I mean, yesterday, the Commission launched its interim report into the Internet of Things report that you've done, sector investigation that you've done. And I just wondered, I mean, I think that the final report is likely in 2022. I mean, on papers like that, are you going to have a job wrestling whether or not to bring follow-up investigations under your existing tools, or to consider how the DMA might be able to deal with some of those issues, like voice issues in the digital market?
Well, you didn't specify, but I suppose this one is for me. And, no, well, first, it's not that we. Well, I agree with Andreas. I think we will manage to get the proposal approved under French presidency, so in the first semester of 2022. And you're right, the first cases will not come before 2023. And it's not exactly that we will sleep in the meantime, but we will need to draft the guidelines. We'll need probably a few delegated so secondary legislations, and we will need to build up the team that will enforce this. But also we will need to process the designation process, because as you've seen in the draft text, it's not something that happens in a split second. So all this will keep us busy for the 6 months or a bit more before the first cases come. Secondly, what's the bearing on the enforcement of Article 102, which is essentially your question? Well, you know, we started this process a bit more than a year ago. And as you mentioned yourself, there is no sign that we slow down our enforcement of Article 102. And I don't think you will see a sign in the future that we will slow down. First, because, as I said in my initial remarks, the DMA is not the end of 102 enforcement. And in particular, because it is meant to be self-executable. So self-executable is necessary to have legal certainty about what you can do, what you cannot do. The slight issue with self-executable is that you can circumvent by doing something that's just a bit different or different enough not to be caught by the prohibition, but not different enough not to reach the same effect. In this case, we have tools in the DMA, and we have still 102. Plus, I'm very confident there's one thing in which I strongly believe, and that is the limitless imagination of human beings. So we will see new practices that we have not seen yet, and that will not be caught by the DMA, that we will need first to address through 102, and so that can eventually maybe feed into the DMA through further legislative process if we need to complement the list.
Okay, Olivier, thank you very much. And indeed, Andreas, both. I think that we've used up the half hour with the extra time that we were given from our previous session. So thank you very much indeed for joining us for this quick update. And Paolo, if I could pass back over to you.
Yes, thank you very much. Okay, right, I'm back. Hard time starting back my camera. Okay, thank you very much to Olivier, Andreas, and Jeremy for this very interesting discussion and for the update about the legislative process on the DMA. As you have seen, this is a very, very hot topic, of course, for all antitrust practitioners. For the competition authorities, for the law firms, for the companies, etc. So I'm very pleased we had this discussion today. So this discussion will end the second day of the festival. But the festival, as I said, is not over yet. So we have the third and final day tomorrow. We're going to have 3 sessions. So we're going to start at 2:30 in Central European Time, and we'll end the session in hopefully in time tomorrow. Okay, so stay tuned and hope to see you all tomorrow.